The Vanzan CEO strikes again. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. What a tangled web she weaves. As I told you yesterday, Justin Baldoni's publicist, in her litigation against his former publicist, filed a motion to compel from Vanzan. Jen Abel, his current publicist, had a very messy split from Stephanie Jones, his former publicist. Jones found out that Abel was leaving to start her own PR agency, so she fired her instead of letting her quit, took her devices, cell phone and laptop, and then that very same day that she terminated Jen Abel and improperly, according to her, ceased her personal devices and sensitive information, including health information, that same day, the publicist for the Plantation Princess somehow found out some of the things that Jen Abel was saying. So Leslie Sloan hit up Melissa Nathan. This is like literally a series of books. This is novel after novel and just riveting. I'm fascinated by it all because it's such a truly tangled web. Leslie Sloan threatened Melissa Nathan, the crisis communications expert. It's unclear if Stephanie Jones handed over everything willingly to Team Delulu, but the Vanzan lawsuit was filed. That's a company of hers or her husband's, TBD. And they filed this anonymous lawsuit back in the fall where they did not notify Justin or Jen or any of the Baldoni Wayfarer parties. But this anonymous lawsuit for breach of contract, which, how did Justin Baldoni have breach of contract with the Vanzan company? He didn't. Anyways, they were able to get Jen Abel's communications legally and be in possession of them. So that led us to this week. Jen Abel filed a motion to compel Vanzan to share everything related to communications with Stephanie Jones, the subpoena in question. Info on the structure of Vanzan, including stakeholders in the company. Who are they? Relevant information, I think. Well, yesterday, the Swift Repellent's lawyer, Ezra Hudson, told the judge that the information has already been handed to Jen Abel by Blake Ruin Your Livelihood. However, that's not what they were seeking. Jen Abel was seeking information directly from Vanzan, not from Taylor Swift's former bestie. And the information that was handed over back in May last month was missing metadata. According to her own lawyer, the Jones Works documents were produced to Miss Lively without certain attachments and without the metadata. The Jones Works documents lacked corresponding metadata. Shady. Some things are purposefully being hidden from us, like dates, relevant, again, the dates. When was the subpoena handed? When was the information given? Etc. And it was odd that Ezra Hudson was responding, even though Ezra Hudson and her law firm don't represent Vanzan. Well, today we have heard from the Vanzan lawyer. They say, "We write on behalf of non-party Vanzan, Inc." in response to the letter motion to compel filed by defendant and counterclaimant Jennifer Abel, seeking certain documents pursuant to a subpoena. the subpoena. The motion appears to be yet another attempt by Abel and the Wayfarer parties to use these legal proceedings to continue their negative media campaign against Blake Lively and her associates, this time by seeking documents from a third party that Abel already possesses or are irrelevant to any of the claims or counterclaims in this litigation. It should be noted for the record here in my video that Jen Abel is being represented by the same law firm that is representing Justin Baldoni in the bigger litigation. And I think the information that is being sought by Jen Abel is highly relevant. And she did not receive the information requested from Vanzan. There is some subpoena dodging going on here from the Vanzan scam shammers. The Vanzan objection to the motion to compel continues, saying the only justification Abel offers is the Wayfarer party's time-worn argument that there was something improper with respect to the Doe lawsuit Vanzan filed in New York State Court, which uncovered scathing evidence of Abel and the Wayfarer party's retaliation campaign against Miss Lively. It didn't do that. In fact, I remember over and over again, Jen Abel and Melissa Nathan were talking about, oh, I didn't plant that. I wish I could take credit for that. That wasn't me. Talking about how everything happening, the reactions were organic. And as I told you, people did not like her being cast as Lily back in 2023, way before any of this. A lot of those same people were probably the ones that spearheaded the movement that started to rise up when reports first surfaced back in the summer of 2024. This latest letter continues saying, Abel offers no legal or factual support for this argument because there is none. What's more, Abel attempts to mislead the court by suggesting that two of the subsets of documents she requests, the subpoena issued by Vanzan, the Doe subpoena, and the corresponding produced documents from Jones Works, are not fully in her possession when she knows they are. And B, that Vanzan has somehow been uncooperative when in truth Abel abandoned the meet and confer process and filed this motion out of the blue after no communications for 3 weeks. That is all alleged. I'm sure Abel and the Wayfarer attorneys would probably disagree with that assessment. And as I said, the docs were handed over by Blackface Blake, not Vanzan. Their letter continues, this motion to compel should be denied for 2 principal reasons. 1, Abel has already received the only potentially relevant documents, the underlying materials produced in response to the Doe subpoena, and 2, the remaining requests have zero relevancy to any claim or counterclaim in this litigation. False. I think everything else being requested, which was already narrowed in the spirit of cooperation and getting this done, that info that Abel wants is highly relevant. But they continue, the remaining requests have zero relevancy to any claim or counterclaim in this litigation, are moot, and or should be obtained from the parties. However, as set forth below, to expedite this litigation and reduce the burden on the court caused by Abel's unnecessary motion practice and abandonment of the meet and confer process, Vanzan will voluntarily agree to produce documents responsive to requests 10 through 11, even though Abel already has them, and to request numbers 1 and 4 based on Abel's narrowed requests, as articulated in the motion to the extent described below. For the rest of the requests, they are saying that Abel should get them directly from Stephanie Jones and Jones Works and or their counsel concerning the Doe lawsuit. Abel should obtain those documents directly from Miss Jones, Jones Works, before burdening third-party Vanzan. Okay, that is a somewhat sensible claim that is 50-50, I would say. Depends on how Judge Lyman rules. They continue, though. As an initial matter, the motion is notable for what Abel omits from it. Abel fails to inform the court, why are they repeating this? That she abandoned the meet and confer process. Counsel for Abel and non-party Vanzan conferred regarding the subpoena on May 27th, 2025. During that conference and in a follow-up email, Vanzan highlighted its various objections to the subpoena. Nevertheless, to resolve the dispute without the court's involvement, Vanzan offered to produce 2 of the items that Abel now seeks, specifically the Doe subpoena served on Stephanie Jones in the New York litigation and the documents produced by Miss Jones in response. Vanzan confirmed this proposed solution via email on May 30th and offered to further confer. Counsel for Vanzan did not receive a response to this email, even though by that time Abel had already received production of the subpoena and responsive documents over a week before that. 3 weeks later, Abel filed the instant motion without any notice to Vanzan, obscuring the fact that she already had the documents in her possession. Further, as a threshold issue, Abel's motion should be denied because Abel fails to demonstrate how the documents are relevant to the claims or counterclaims in this litigation. Abel has a far-fetched theory that the documents are relevant to her amended counterclaims. Abel's amended counterclaims, of course, are currently subject to pending motions to dismiss, which, if granted, would eliminate the issues in the motion entirely. But Abel's counterclaims are at heart an employment dispute with her employer, Miss Jones, and have nothing to do with Vanzan. The claims arise from events Abel says occurred when she was terminated and her cell phone was obtained by her employer in August 2024. Events in which Vanzan is not alleged to have been involved in any way, and which took place weeks before the Doe lawsuit was initiated on September 27th. That was quick. Moreover, the requests also seek documents that are more appropriately sought from Plaintiff Jones or other parties to the litigation. Vanzan is not party to any litigation involving Miss Lively and the Wayfarer parties. Further, Abel already received the Doe... Okay. Oh my God, your repetition is... No wonder earlier today I told you that Judge Lyman told her lawyers, you've got 2 pages max for your objection to Jed Wallace's motion to dismiss. They are going on and on in circles, repeating themselves. The judge is not, well, some people might say he is, but the judge is at least a university graduate, okay? He's not a total idiot. Abel already received the Doe subpoena and documents from Miss Lively, a party to the related litigation with Abel, and any communications involving Miss Jones, to the extent they exist, should be obtained from her through document requests Abel has made to Miss Jones. Ultimately, the motion is consistent with Abel and her counsel's pattern of using the court's docket to advance public relations narrative in the media. If that were not their goal, Abel would have continued the meet and confer process, or at least responded to Vanzan's May 30th email and informed the court she in fact possesses the information she now seeks. To the extent Abel maintains that she should receive a second copy of these materials so that she can confirm information she already has, motion at 3. Then Vanzan agrees to reproduce those materials as previously offered. Would reproductions? I don't know how that would work, if that would be good enough. If it's certified and has metadata, okay. In addition, they wrap up, to help resolve the dispute without further burdening the court, Vanzan will produce its articles of incorporation, which I told you they were seeking, which are publicly available. They are? Oh, okay, I didn't know that. And written consents of Vanzan's board of directors, which reflect its officers and shareholders. If it's publicly available and easy to share, why didn't you include that now? Why didn't you let us know that already? Or previously when requested then? Huh? As for request 9, any responsive communications with Ms. Jones' works, to the extent they exist, would be in the possession of Ms. Jones' works, and should be requested from and produced by Ms. Jones, the party of the lawsuit. For the reasons stated above, we respectfully request that the court deny defendant's motion in its entirety on the merits, or alternatively because it is largely moot. I think your response is largely poot. Poot. Does that mean anything, poot? Oh my God, that works so well here. I just looked it up and I was reminded poot is slang for fart. How appropriate. I think I've got a new nickname. All right, my fam. I think Vanzan is being shady, evasive, hiding things, purposefully misdirecting the judge. Extra shady. What do you think? How do you view this response and everything going on? Let's discuss all in the comments section. And until I see you again next, I am Perez, the queen of all media, the original influencer, and your #1 source for everything It Ends With Us saga. See you in the comments section.